I do. What I do on a monthly basis, I travel around the province of Ontario conducting seminars on all aspects of the liquor laws for our external stakeholders. And that involves, of course, people who are in the alcohol business on a day-to-day basis. So we're talking about licensees, managers, staff members, security, anyone who works in the alcohol industry. We invite them out to our seminars. We also do seminars when I'm on the road for specialists. A lot of event organizers look to us and come to our seminars because of all the events that are happening around Ontario. So that is what I do on a day-to-day basis. I do a lot of traveling and a lot of talking. Want to change for me now? Oh.
Let's try this. Go ahead.
Thanks, Dan. Or Kayla. Okay, now that we have our technical wrinkle ironed out, what we're going to do this morning, and you are the paralegals and the Paralegal Association, so this is a different kind of tack for me as far as addressing it. Usually I'm talking to licensees. Now I'm talking to those in the legal industry. So we're looking at it as a different way. I did go to your homepage and have a look, and it did say, and then your invitation was to invite you out this morning and learn more about the AGCO, and that's exactly what you're going to do. So for my own knowledge, how many of you in the room have actually worked with liquor licensees or had any dealings with the AGCO? Okay, so we have a few of them, and I have no idea how many of you at home put up your hand, but that gives me a good idea. Because of the fact if you haven't dealt with licensees, if you haven't dealt with the AGCO, you might want to look at that also as a different career option. So some of the things I'm going to go through are also slanted in that direction, that you're not only going to learn about what we do and how we do it, but also think about how you as a paralegal may want to fit into that system and look for some opportunities. So first of all, let's have a look at the AGCO. The Alcohol and Gaming Commission of Ontario is an arm's length agency of the government. It was formed in 1998. Now, an arm's length agency of the government is, yes, we are part of the Ontario government. We operate on an arm's length, which means that our CEO, also known as the registrar of the Alcohol and Gaming Commission, has the authority to make decisions without contacting the actual government. We report to the Ministry of the Attorney General, so we are part of the AG. But if the registrar wants to make a recommendation concerning a license or anything like that, the registrar can do that without the permission of the Attorney General. So we do operate at an arm's length, but yes, we are part of the government. It was formed in 1998. Formerly, the Liquor License Board of Ontario, otherwise as we all know it as the LLBO, and that was 1998. And I still drive around the province every month and I see brand new signs, licensed under the LLBO. And I always think, wow, you're licensed under an agency that hasn't been around since 1998. So we don't want any confusion as to how many liquor licensing boards do we have in this province. There's only one. The Liquor License Board of Ontario was amalgamated with the Gaming Commission Control, which has been around in 1994 when gaming became legal in Ontario, to form the Alcohol and Gaming Commission of Ontario. And what we do, of course, we are the regulator. We regulate the beverage, alcohol, and the gaming industries. So gaming, we're talking about casinos, we're talking about lotteries, we're not talking about hunting and fishing, a different type of gaming. More things that we do in a broad scope. The AGCO is responsible for licensing and inspecting establishments that sell and serve alcohol. So we do issue the licenses, all of the alcohol licenses and liquor sales licenses in the province. So any bar, any restaurant, any stadium, any social club, any event is licensed by the AGCO. We also license the ferment on-premise facilities, what we all call U-brews or make your own wine, those places. We license the liquor delivery services, the people who start their business to deliver liquor to people in their houses. We also issue the special occasion permits. So anything to do with licensing is the responsibility of the AGCO. We also license on a higher level the Ontario manufacturers of alcohol. So we're talking the breweries, we're talking the wineries, we're talking all of the distilleries. They are licensed by us. We also license the representatives of the breweries and the wineries and the distilleries. The manufacturers' representatives are licensed by the AGCO to represent their manufacturers. And we also authorize retail stores. So as I mentioned, today we're talking about the liquor side that the AGCO performs and the mandate we have and the duties that we do as far as alcohol is concerned. So as I mentioned, from your perspective as paralegals, when we're looking at, okay, what happens in the industry, right, for licensees, what we like to do is take you right from the grassroots of the licensing process. And while I'm doing this, as I mentioned, you can think of how the industry. But in order to understand, what happens at the end of the process, as you may know, obviously the AGCO is the regulator. So you may think, oh, you're the people who hand out infractions. Well, let's go right back to the beginning and find out exactly how that happens, if it happens. So we look at liquor sales licensing. Anyone in the province is eligible to apply for a liquor sales license. And there is only one main license in Ontario. Other provinces have up to 5 different liquor licenses. Some of you who've been on the planet for a while may remember years and years and years ago when Ontario had a few different ones, tavern license, restaurant license, but we only have one main one now, the liquor sales license. So anyone can apply as long as they're of legal age and as long as they're eligible. Here's the exceptions. They're eligible for a license unless they are proven not financially responsible. If their past or their present conduct provides reasonable grounds that they're not going to carry on business in compliance with the law, or they're not going to carry on their business with honesty and integrity. If someone makes false statements on their application or they provide false information to the AGCO, then they will be deemed ineligible for a license. If their activities do not comply with the act or the regulations, if they can't prove that they can demonstrate sufficient control over their business and over the premises that are licensed, and if the AGCO decides that granting this person or this corporation is not in the public interest, then they would not be eligible. So, getting a license, what happens? The licensing process. I get a lot of these questions when I'm out on the road. I'm not just talking to liquor sales licensees and people in the industries. I get a lot of people who want to be in the industry and have no idea how it happens. So this is how it happens. How can you get a liquor sales license? Well, there's 2 situations. Someone can make a new application. Someone can apply for it, get their proper paperwork, and do it all of themselves, or they can enter into an agreement where a license is transferred to them. So that would be an existing license. Someone is selling their business and they want to take it over and have their license transferred. So if someone is actually applying for their license, this is the requirement list that they would have to go through. Generally, the application process to get a liquor sales license takes between 10 and 12 weeks. It's a lot of paperwork, and a lot of new applicants rely on folks like you to do the paperwork. They hire paralegals to do that for them. So this is the process. Some paperwork is needed immediately for the process to start. Some paperwork can wait for a while before the issuance of the license. So we would need the application form, the all-important application fee, which is $1,055. We need a description form, and all of these forms are available on our website. We need a description form of the establishment. We need corporate structure form if someone is starting up with a corporation. Personal history reports need to be done. And again, we go back to what I mentioned before on eligibility, on the honesty and in the integrity of the people who are applying. The personal history report will show that. Also, we would need floor plans of the establishment that they intend to start up or run or take over. Later on, and again, that's immediate. Later on, before we issue the license, then these things definitely have to be in, but they don't need it. They don't need it right up front. So municipal information from the municipality, agency letters of approval from building, fire, and health, capacity calculation of the establishment. We need their business name. They need to be registered with the Ministry of Government Services, and then eventually one of our inspectors would go out and do a pre-licensing inspection. So a lot of steps to go through for someone to obtain a liquor sales license. When it comes to someone who wants to have a license transferred, it's a little different because the license is already in existence. It's not the person who is licensed, it's the address, right? So the license actually doesn't belong to that person, it's the address that is licensed. So therefore, the liquor sales license is not included when somebody buys a business. If you want to go out and buy a bar tomorrow, you can buy the bar, but you won't get the liquor sales license with it because it's not part of the package. So the business deal would be separate. So they would have to go through the application process. And again, let's say I'm selling my business to you. You come to me and say, I want to buy your bar. Okay, great. I can tell you there's two ways to do it. You can go apply and get your own license, get all the paperwork done, or let's get together and you can apply for me to transfer my license to you. And that's what this process would be, that we're going to contract out. And what that means is with my approval as the licensee, I'm going to contract out my business to you through the AGCO, let them know about it. And again, a lot of paperwork, legal paperwork. And then we would both run the business at the same time while all the paperwork is being done at the AGCO head office and the legal commitments are being met. Then when that is over, then you would have my license transferred to you. Our business deal would close. I would head off to the sunny south for the rest of my life. So that's how that would do it. The two ways of getting the liquor sales license. Someone can do it by themselves, or it can be transferred to another person. Either way, a lot of legalities to fill and a lot of paperwork to do. Once someone has a license, this is the way the licensing process goes after they're in business. When someone receives a new license, the new license is valid for 2 years. Then after 2 years, it's time for more paperwork. It's time to renew that license. So we send them out a renewal notice. We send them out, it's like your driver's license. You get a renewal notice, right? 60 days. It's not an obligation on our part, it's just a reminder. They renew the license and it's valid for another 3 years before they have to go through that process of paperwork again. If someone's license expires, and we always stress this with the licensees, do not let the license expire, because once the license expires at midnight of that day, you cannot sell and serve alcohol. And expired licenses cannot be renewed. So there's more paperwork involved because they would have to apply to have that license reinstated, which is not a huge deal. However, between the time that the license expired and the time it gets reinstated, they cannot sell and serve alcohol, and that is their business. So we stress very strongly that licensees make sure they know what the expiry date is. It's printed on every license, and make sure they get their renewal in on time and have their fee in on time and all the paperwork done. At that time, they can change their establishment name. They can do all kinds of different things when they want to renew. Again, we're talking paperwork. Any changes that have to be made must be reported to the AGCO so that we have the proper information in the database in case we need to contact them. But what happens when an establishment closes? Somebody wants to close their business for good. Well, again, the license does not belong to the person. It's like our driver's licenses, right? It's a privilege, not a right. So when a business closes for good, somebody liquidates it or whatever, or doesn't do the transfer, has somebody buying it but tells them to get their own license, they must surrender their license back to the AGCO, because again, they can't carry it to another business. It is licensed to that address. So we definitely stress that that license belongs to the province, so it must come back to us. That is the process that everyone goes through to obtain a liquor sales license. Then after the running, as I mentioned, there's only one liquor sales license. However, there's other agencies can add to their license. and they are called endorsements. Piggybacking onto their license that allows them to do more things than just a liquor sales license allows them to do. They're called endorsements. A licensee can apply for different types of endorsements to add to their liquor sales license. There's no limit to the number of endorsements they can apply for. Right? It's not another license. It's not a permit. It's an attachment to their liquor sales license. As long as they have a valid liquor sales license, they can apply for these endorsements. They can apply for a brew pub or a wine pub endorsement. Now, this is not a manufacturer's license. This is different. This allows them to sell and serve beer or wine that is manufactured by the licensee on the licensee's premises for consumption on the premises. You may have in your lifetime been in a brew pub or a wine pub. And again, they're not selling it. It's not a manufacturer's license. That's different. They're just selling it inside. And again, when they go to the endorsement and they're going to do that, they have a lot of things to prove that they own the equipment, they own the premises to get either a brew pub or a wine pub endorsement. The other one is that considers with alcohol is bring your own wine. You may have seen this at some of the restaurants and wondered, oh, how are they allowed to do that? This allows patrons to bring their own wine into a restaurant that already has a liquor sales license or a banquet hall that is attached to an establishment with a liquor sales license. If you've ever seen somebody bringing their own wine into a restaurant and wondered, when did that happen? This is because that restaurant has a bring your own wine endorsement. So someone can bring their commercially made wine into that restaurant or banquet hall. The next one is a caterer's endorsement. If you've ever organized an event, you may be aware of what a caterer's endorsement is. This is an endorsement that someone can have attached to their liquor sales license that allows them to sell and serve alcohol in an unlicensed area of a licensed premises. So, you know, if the Legion here was licensed for this room and the upstairs wasn't, the caterer's endorsement could be used in that room right now because it's unlicensed and they're allowed to do that. Or they're allowed to sell and serve alcohol at a catered event that would qualify for licensing. So what happens is, in a nutshell, that if I'm the licensee, I've got a caterer's endorsement on my license. Someone's holding a special event. They want me to cater into that event. They want me to cater food and alcohol because I have a liquor sales license. They can do. That's how that would work. I can't hold my own events. An event organizer would have to come to me to do that. I'm sure there are some of you that are familiar with the golf course endorsement. That allows the selling and serving alcohol on the playing area of a golf course. Without that endorsement, they would not be able to sell alcohol out on the course to the golfers. Mini bar and room service, of course, they apply to hotels and motels that already have a liquor sales license to have that apply. So the reason I go through these is so that there's no confusion, and sometimes there is, that how many licenses do we have in Ontario? And it can get mixed up. Was that a separate license, or what's a special occasion permit? Is that another license? There is only one license. Everything else would be an endorsement or a permit. So these are the endorsements that licensees can have. They apply for them. The only one that costs money, every one of these is free except for the golf course endorsement. Otherwise, there's no charge. Something else that has affected licensees in the last few years is something called primary use. Primary use is one of the biggest changes that has happened, in my opinion anyway, in the Liquor License Act in the last few years. The Act is like a living, breathing thing. It changes every few years. Every few years, the government takes a look at it. We're going to have a little look at it later, but every few years, the government takes a look at the Liquor License Act because public tastes change. The way we live changes, right? And the Act has been around since about 1926, but our lifestyle has changed a lot since then. So every now and then, the government will have a look at the Liquor License Act and say, okay, let's modernize it a little bit. And this was one of the changes that was done in 2012 to modernize the Liquor License Act. And that is primary use, or actually removing the primary use from the Liquor License Act. Up to 2012, when you applied and you received a liquor sales license, it was the law that in that licensed area, you could only sell and serve food and alcohol, and that's all the businesses you could run in the licensed area. That was called the primary use of the licensed area. Anytime you ever went to a bar or a licensed place, you never saw a lot of other things going on except food and alcohol, right? That was removed from the Act. That was part of the previous government's Ontario Open for Business program to loosen things up a little bit. So now, without primary use in the Act, it is legal for any licensee to operate another business inside the licensed area besides food and alcohol. So you say, well, what does that mean? What other business can you run inside a licensed area? Once you got a bar, you've got a bar, right? You're not going to run a mini putt in the back corner. Well, it was on the flip side mostly, that if somebody owned another business along with it, they could license that. So for instance, if I had a golf course and I've got my bar, otherwise known as the 19th hole, and I've got the pro shop attached to the bar, you would not be able to go into the pro shop previously with a drink in your hand because it's not licensed. It's a separate business. But without primary use, I can now put a liquor license and have that entire area licensed, both my bar and my pro shop, and somebody could actually wander through the pro shop with, you know, a drink in their hand and shop. It's not that, you know, I'm going to have the person behind the counter selling teas and Crown Royal next to each other. It's just more of a convenience thing, right? Or if I had a fine dining restaurant on the main floor of my building and an art gallery on the second floor, I could put the license to the art gallery too and have people wander around the art gallery with a drink in their hand and buy art. So I'm running another business inside a licensed area. It was quite a big change for some licensees. It didn't affect all, but it did allow them to run another business inside the licensed area. Probably the flip side of it was the bigger change, because it also allowed anyone in Ontario with a business license to apply for a liquor sales license, which would be the other side. So you may have heard at the time, if you're following the laws, which you probably do, I'm sure, as soon as that act was changed, a lot of businesses in the service industries jumped on and applied for liquor sales licenses. And a lot of them were spas, ladies spas in the GTA and the Horseshoe region, so that ladies could have a wine or whatever they wanted to serve them when they went to the spa and got whatever it is they get done in a spa. Being done, they could have a drink while they're doing it. So that was a big change, right? And the service industry thought that was great because now they can add a little added value for their clients. So it's open to any business. Chances are in the future, you're probably not going to be going down, you know, to Mr. Lube, getting an oil change, having a few beers, and then getting back in the car, driving home, right? But again, it doesn't stop them from actually applying for one. So it was a big change to the act. So you're probably going to see more and more of that as we go along in Ontario. And again, another business opportunity for you, right? Because people can do that. They can apply for it. One of the other things when we're following along with the laws and how the liquor license itself works, when a licensee does changes to the licensed establishment, sometimes they have to apply to us for approval if they're making some major changes, and sometimes they don't. And it gets a little confusing for them. Well, do you need to know this? Do I have to have a permit for this? And that concerns renovations and alterations. They still need to apply for an application or paperwork, and they need approval if they're going to change the perimeter of their establishment or the licensed area, right? If they want to expand their existing licensed area. Usually starting in the springtime, we experience a rush of patio license applications from establishments that didn't have patios before. All of a sudden, oh, I didn't realize summer was coming. And we get a lot of applications for that. So they do need to have an application in. They do need approval before they add a patio onto their establishment. One of the other changes in the act was the ability to license tiered seating. So, you know, you're looking at theaters, hockey arenas, things like that. You can have tiered seating license. You can also license temporary tiered seating. So if you were having a baseball tournament and you want to bring in temporary bleachers for that, You can set up the temporary bleachers and have them licensed. But if anybody is going to do that, again, they need approval from us, to have that license, because it's done on a case-by-case basis. So some things they need paperwork for, and some things they don't. If they're just going to change things around, if they're going to do some painting and things like that, changing their decor inside, moving their doors around, they don't need the paperwork. They don't need approval from the AGCO. Biggest one is, of course, when they're adding additional seating, right? That we need to know. We have to have that application. Not necessarily a patio license, but they just want to increase the size inside, maybe, because they feel that they can be licensed for more people. Then we need approval for that. But if they're doing all these things, pretty well cosmetic changes to their business, they don't need to do a lot of paperwork on that. When they're doing the changes, right? Somebody comes to you and wants you to handle the paperwork and that. When they're doing the changes, it's very important that we stress with them, make sure that your licensed and your unlicensed areas are still separated, because that is the law. If there's a licensed area next to an unlicensed area, then it has to be separated by a partition or wall that is either 36 inches or 0.9 meters, that's the same, what we used to call 3 feet, high or higher, depending on the recommendation from the AGCO. But that is the law. The licensed and the unlicensed area do remain separate. Okay, so we're just going to touch on the Liquor License Act and the regulations. I'm not going to go through the entire act. We'd be here for a couple of days, maybe a week, because the Liquor License Act is a large piece of legislation. Has anybody ever read the Liquor License Act? Nobody at this table answer. Anybody here ever sat down and read the liquor license? It wasn't written by Stephen King, okay? So when you're reading the Liquor License Act, it's very important to know what section to look at, not only for the licensees and the people who are working in the industry, but if you're working with a licensee, because you look at it and say, okay, where is this in the act? Because it covers everything, all of the licensing. So we're talking about sections that deal with manufacturers only. We're talking about a regulation 389 that only deals with special occasion permits. And if you're looking for something for a liquor sales licensee, you wouldn't be looking there. So where do you look? What do I plug into ELAWS, to find what I'm looking for? Well, the Liquor License Act covers all of the aspects of Ontario's laws when we're talking about sale, service, and consumption of alcohol. So you'll find things like how to get a license in the Act, how a licensee can keep their license. Basically, the things I just went through, those things are all in the Act. Infractions are covered in the Act. How does someone in the industry know they're breaching the law? They look it up in the Act. But where do they look? Regulation 719, or 71990 to be specific, that details the responsibilities, the specific responsibilities for liquor sales license holders. As we go through, you will see us pop up Regulation 719 subsections through our presentation, and that's the one that deals with the day-to-day operations for a liquor sales licensee and the staff members. Because again, it is a large document, and as I said, not a fascinating, well, we know, right? You look at laws, you look at regulations, and you look at acts. They're written by lawyers, right? So sometimes it's kind of hard to find out what exactly you want to find. So that's where we find it for liquor sales holders and the people who work in the industry. This brings us to liability and responsibility. If you look these up in the dictionary or a thesaurus, you'll find that in the English language and our everyday conversation, they're interchangeable. Right? People interchange these words all the time. But as you know, from working in the legal aspect, a lot of times liability and responsibility may not be the same thing. And what we stress with the licensees and the people who work in the industry is that responsibility is different. It starts with you who are working in the industry. You are responsible for knowing what you're doing and knowing the laws so that you don't end up liable for something. It is an offense for any person to contravene any provision of the Act or the regulations. When it says any person, it means any person. Sometimes, and I've heard this from licensees, sometimes in the business you'll get, and think back to maybe when you were going to school or you were going to college or university and that, we all did jobs that had nothing to do with our chosen field, right? We did jobs just to put, our hospitality industry is large with a lot of people who, they get their smart serve and they work as servers, they work as bartenders, they work as security or whatever. To put themselves through school maybe, or make extra money or whatever, but it's not their chosen field. So they may not have that sense that they could be liable because something goes wrong. Talk to the boss. I just work here. Yeah, I just work here, exactly. I just do what I'm told. I don't know, which is not the attitude anyone can have in this business, right? Because you can't say, I don't know. That's where the responsibility is. And those are the things that we stress, especially upon staff members. Licensees, managers, yes, they're in the business. They own the business and they know that this is their livelihood at stake. But if somebody's working part-time on weekends, putting themselves through school, they may not have that level of consciousness for responsibility. And same thing is if you know people who do events. You've got volunteers who aren't even being paid to do that job, so maybe they're just there to help out a friend. But when it comes to this, when it says any person, it means any person. So it doesn't matter whether they're there on weekends working part-time to go through school. It doesn't matter whether they're volunteering for an event and they've got their smart serve, so they volunteered to help out bartending or pouring beer at an event. It doesn't matter to the law what you're doing. What matters is someone committed an offense. So it could include those employees that are involved. It could also include the director or the officers of the corporation, right, that set up the company. If a director or officer caused the offense, if they authorized the offense, if they permitted the offense to happen, or if they actually participated in that offense, then they can be liable for that. The monetary values you see on the screen, those are not set by the AGCO. We do not have anything to do with court fines. That's set by the court. If somebody ends up in court, then it's a different ball game. A corporation can be liable for a fine up to $250,000. Any individual, again, we get back to anybody in the industry, they're liable for a fine up to $100,000 or to imprisonment up to a year or both. And if we're talking about Section 30 of the Act, and that's serving minors, that's a very serious offense, those caps are doubled to $500,000 and $200,000. And again, those figures are in the court. We do not set that. That's out of our hands. That's in the court. When it comes to the AGCO, of course, we look after the license. So there's different administrative action that the AGCO can take, which I will talk about a little later. So when we're talking about liability and responsibility, again, we look at who can be held responsible. Pretty well all of these people can be held responsible. The patron, yes, the patron, the corporation, directors, officers of the corporation, the licensee or the license holder, the managers and staff. When it comes to what I want to show you right now is a short video. It's not very long. You may remember the content. I don't know if you've seen it. It's actually a segment of W5 from a few years back when we're talking about liability and responsibility. And it helps to explain why the Alcohol and Gaming Commission of Ontario does what it does and why our inspectors and everyone who works at the agency is very passionate about responsibility and liability and fulfilling our mandate. There's a couple of prominent cases in this segment from W5 that happened in Ontario that you will probably remember. This was aired before the outcome of those cases, and I'll let you know what they are afterwards.
W5 continues.
Did everyone hear that? We can crank it up a bit.
Welcome back. A A fatal car crash in Ontario cottage country last summer, which saw 14 people charged with supplying liquor to apparently intoxicated persons and permitting drunkenness, has reopened the debate into how responsible are bar owners and employees when they serve alcoholic drinks. On one side, there are those who say that bartenders are being turned into babysitters and shouldn't be answerable for the actions of their customers. Others argue that over-serving alcohol is a major problem, and licensed establishments must be accountable if they continue to serve those who appear to be intoxicated. And as Paula Todd reports, the fear of being held liable for the actions of their customers has many bar workers wondering when is the right time to serve or protect.
The town of Cambridge in southwestern Ontario. Kelly Brooke is making a journey no mother should ever have to make, to place flowers on her young son's grave.
My son Kevin went out with a friend. I had just come home from work and said goodbye to him.
21-year-old Kevin and his friend Catherine Wolpole, 22, drove to a local bar called Moose Winooski's.
They were there for approximately 2 hours, and during that time they were served 4 54-ounce pitchers of beer, which works out to approximately 9 beers apiece.
After serving all that beer, the waiter told Catherine not to drive. Catherine said she wouldn't, that her mother was picking them up.
Her mother lives in Hamilton, and that's not what was going to happen. They were coming to our house.
As they left the bar, they were visibly drunk. The bartender told them to take a taxi. Kevin called one, but Catherine refused to get in.
She was verbally abusive with the bar staff, said she would not get into the taxi. She wanted to drive her car.
The taxi left. Kevin and Catherine said they would walk the 2 kilometers to the Brooke residence.
They did begin to leave the parking lot, and the bar staff went back inside. They came back out to check on them and found out that they had turned around and doubled back.
By the time the bar staff noticed Catherine was getting into her car, it was too late.
The bar manager came over and pounded on her window and said, "Get out of the car." The car sped out of the parking lot. 911 was immediately called.
Kelly Brooke was awakened by loud knocking in the middle of the night. It was the police.
They said to me, "There's been a very bad accident and we believe Kevin has died." And I just fell to pieces. I began to, I screamed out, "No, don't tell me that."
Catherine Wolpole had lost control, and the car smashed into a cement hydro pole, crushing Kevin, killing him instantly. Kelly Brooke and her children said their final goodbyes to Kevin at the hospital morgue.
I laid on his chest and cried hard, saying, my baby. He was a man. He was 6'1", but he was my baby. I asked the orderly for a bowl of warm water. I didn't want my children to come down and see him in that condition, and because there was a lot of blood.
Catherine Wolpole had a few scrapes and bruises. She's been convicted of 236, almost 3 times more than the legal limit.
They said in court that at first they didn't smell alcohol on her breath because the scent of blood was so overwhelming. And that was very upsetting to us because she didn't have any significant injuries, only bruising. So we knew that that was Kevin's dying blood.
And the bar, Moose Winooski's, could have its license suspended for permitting drunkenness. They'll face a hearing at the Alcohol and Gaming Commission. where CEO Jean Major has no tolerance for bars who serve too much alcohol.
I've seen young people passed out in bars. I've seen people vomit in bars. You can't mistake intoxication when you see a young man carry a young woman in his arms out of the bar.
Back in Cambridge, Kelly Brook doesn't have much sympathy for bars that overserve and thinks Moose Winooski's should get more than a mere suspension.
They served an obscene amount of alcohol, in my opinion. I find it unfair that they aren't held criminally liable. Their actions define criminal negligence, in my opinion.
It's no surprise Kelly Brook has such strong opinions. She's a veteran of tragedy, having lost not one, but 2 children at the hands of drivers who were drinking. 4 years before, she lost her 12-year-old son, Matthew.
You say trick or treat?
It was Halloween night, 2003. Kelly was putting the final touches on the kids' costumes. This would be the last time 12-year-old Matthew went trick-or-treating.
He was at a school dance. They had a Halloween dance. And he was on his way home with a group of friends. They were on a traffic island when the light turned red, and they crossed on the red light. And 3 of the boys made it across, and Matthew was struck by a car.
Matthew was rushed to Cambridge Memorial Hospital.
When I saw Matthew, I knew that I was going to lose him. His pupils had fully dilated, and I just knew that the brain injury was significant. And he died the morning of November 1st.
As the fog of despair began to lift a little, Kelly turned her attention to the details of what had happened that night. Her grief quickly turned to outrage.
I was told that the police smelled alcohol on the driver's breath, and they asked him if he had been drinking, and he admitted to consuming 2 glasses of wine, and they didn't do a blood alcohol or a breath. It was the fact that they detected an odor of alcohol, and the driver admitted to drinking, and those were grounds for a breathalyzer. But it was too late, and nothing was done.
How did you react, though, when you realized that your second son had been killed and alcohol was involved in his death?
I was extremely enraged. I still am.
On a cold February night in Toronto's entertainment district, the clubs are just starting to heat up. It's reading week, the midwinter break for university and college kids. Police are expecting up to 50,000 young people, mostly under 25, to let loose at some of the 80 nightclubs crammed into a 1 square kilometer area in the downtown core. Police aren't taking any chances. They patrol on foot, on bike, and on horseback. They flood the area to keep things under control.
You're out here not just enforcing, but protecting people from themselves.
Detective Steve Hinkle of 52 Division and his team are in plain clothes.
I mean, we get a lot of calls to severely intoxicated people, and then we have to look after to make sure that we are next to them, that they go to the hospital, and they get the care they need.
It all adds up to a nightmare for police.
Especially between 2 and 3:30 in the morning, which we call the witching hour, when the bars let out. All we do is, I call it triage policing. We go from one fight club to the other, and it's just bandage and try to put them out.
Also keeping a watchful eye to ensure bars are obeying the law and not over-serving are liquor inspectors Jake Ledbetter and Linda Sandelin. They focus on the bars that have been known to break the rules and that have previous infractions. And if they find anyone under the legal drinking age of 19 or anyone who is intoxicated, the club can have their license suspended and face a fine.
You're allowed into the bar. What are you looking for? We're looking for any liquor license act violations. So a lot of that is what we call the Big Five, the public safety issues, drunks, minors, overcrowding, after-hours service, permit disorderly behavior, and permit use of narcotics.
Their first stop is Mink nightclub. Last summer, Mink was shut down more than it was open, a total of 50 days, for permitting drunkenness and overcrowding. Within minutes of entering the nightclub, Jade spots an underage drinker carrying fake ID. Outside, police take over.
At the end of the day, the bar is in a lot of trouble because you use fake ID and you're a minor. Now you've been into this establishment as a minor and you're consuming alcohol. You're gonna have to leave, but right now, you're gonna be charged.
And as the evening wears on, people stumble out of the clubs and the liquor inspectors continue to check out the strip, searching for more violations.
People get dry order done.
Yeah.
The order's full.
The bar will be written up for permitting drunkenness for one patron.
And last December, the law came down hard on this golf club near Port Carling, Ontario. 3 young men died when the driver lost control of his Audi sports car, crashing to a guardrail, hitting a tree, and then rolling over into the Joseph River. They had spent the afternoon drinking at the Water's Edge restaurant at the Lake Joseph Club. 14 people, staff and owners, are charged with 30 offenses, including serving excessive amounts of alcohol and permitting drunkenness. But Kelly Brooke, the mother who lost 2 young sons to drivers who were drinking, says she can only reach resolution when bars are held accountable for serving too much liquor.
I believe they should be held criminally responsible. If there is personal injury or death, the drunk driver is, and under host responsibility, they are liable for the intoxicated person until they sober up.
Even though employees of Moose Winooski had urged Catherine Wolpole not to drive.
I wonder what they were thinking when they saw the state that they were in and why they didn't just call the police if they were that concerned.
What about Kevin?
It's very difficult for us because we wish, of course, with all our hearts that he didn't get into that car and he made a fatal mistake. And all I can say is that Kevin has paid his price and now the other people have to pay theirs.
Okay, you may remember those cases in the media, and as I mentioned, excuse me, a couple of reasons why the AGCO is doing what it does, aside from being mandated as a regulator, and in those minus 30-degree February nights, now you know where our inspectors are while you're nice and warm in bed. If you remember, this segment was actually a few years old because in both of those large cases, right, in featuring Moose Winooski's and the Lake Joseph Club, they mentioned what they were charged with, but did not mention the outcome. Well, they have gone through the courts since that was broadcast. In the Moose Winooski case, it was 2007 when the crash occurred that claimed the life of Kevin Brock. It was a very, very long series of hearings back and forth, and the decision came out in 2013, so 6 years later. It wasn't just like one hearing and then 6 years to get a decision. It was quite a long time of back and forth hearings. They ended up with their license being suspended for 30 days. at that time. And I'm sure as paralegals watching that clip and hearing the stories, there's all kinds of different legal things going through your head as far as one side or the other. But that was the final outcome. The sanction was for permitting drunkenness and practices that encourage consumption and over-service, or what's also called encouraging immoderate consumption. And even with the suspension for 30 days, the licensee was actually considering appealing that one, but decided not to because it had already gone out for quite a long time. When it came to the Lake Joseph Club, the one where the 3 people died in the car crash that went off the road, their license was suspended by the AGCO for 45 days. Club Link Corporation pled guilty. They were fined $62,500. And the staff member, the server, received a fine for $1,130 for over-service. So again, we go back to who could be responsible. Anyone that is involved in the breaches. And I'm sure there's a staff member. I have no idea who the staff member was, but working at a golf club in the summertime, maybe putting themselves through school or whatever, and nobody wants to go down that road, but sometimes this is what happens. And again, that's why as the regulator, we're very passionate about regulating the liquor licensed establishments. And that includes the work of our inspectors and inspections. So I could stand here and tell you about inspections, but actually what I'm going to do is hand it to Ashley, one of our AGCO inspectors, who can tell you a little bit about her position and what's involved. Ashley?
Okay. So I'm going to talk a little bit about inspections. And any establishment that has a liquor license can expect to be inspected. And that would be by AGCO inspectors, police, and numerous other enforcement agencies. So some of their obligations would be to allow the inspection to take place. So AGCO inspectors and police have the authority to enter and inspect a premise, and that would be at any reasonable time. So if we go to an establishment and we see somebody in there, or they're still serving or anything of that sort, that's a reasonable time. So if I knock on the door, they're expected to open the door and let me in. We have the authority to request documents, records, and invoices. So that could be liquor purchase receipts. Licensees are expected to keep the receipts. And we require them to keep a minimum of 12 months receipts. So I can go in and I can request up to 12 months receipts, and they're expected to provide that to me. Whether they keep that on site or not, it has to be readily available. We do have the authority documents or liquor for examination. So if I see someone drinking something and I'm not quite sure alcohol or not, I can take a liquor sample and remove that and then have a test done on that. Anything that I do remove from an establishment, they would receive a receipt just saying that I took this on this date at this time. I would do a report for, report information to the Register for Compliance Actions or Consideration. So every inspection that I do write a report whether there's any infractions found or not. And at that point, it would go to a sergeant who's going to look it over and decide the disposition on the information that I saw that evening. That would go to our deputy registrar, who's going to determine what sanctions are imposed based on my findings. And we can lay charges in provincial court for up to 2 years after the inspection. So. So AGCO inspectors, as you saw in the video, we don't wear a uniform, we are plain clothes, but we do carry identification. So it looks like this, which is just an identification card and a badge. So I may not identify myself immediately upon entering the establishment, but if I'm going behind the bar or any areas where customers aren't normally permitted, I will identify myself showing my badge and then conduct my inspection. That's just a little bit about inspections. Just going a little bit further, the frequency of the inspections, that would depend on, numerous factors. So that could be public complaints. That might be a reason that I'm going to add an establishment more frequently. It could be perceived risk. So if I keep going to this establishment and I keep finding infractions, that might be an establishment that I might visit more frequently. There's also compliance inspections, which we do at every establishment every 2 years. And then just regular spot inspections, as you saw in the video, just going to different spots on a busy night. So those are some of the types of inspections that we might do on a regular day.
Okay, thank you, Ashley. Sometimes, as Ashley mentioned, she went into the details about the inspections and what the inspectors do. And one of the things that we also impress upon the licensees, but mostly actually on the staff of establishments, is that it is a breach of the Liquor License Act to refuse an inspector entry to do an inspection. What they may not realize, and again, what we do remind them, is that their liquor sales license is much like a driver's license. If it's valid, it's in effect 24 hours a day. Right? It doesn't stop being valid at 2 a.m. when they stop serving. So if Ashley or Adam show up at the door at 10 to 3, they can't say, oh, hey, sorry, come back tomorrow, we're closed, because they're not coming in for a beer. And as long as a licensee has a valid license, then it's valid 24 hours a day, 7 days a week. It doesn't stop. A little bit more about, and again, we're going to open the floor for questions a little later on if you have questions about anything from myself or the panel. So keep that in mind, because I know inspections are always interesting things to ask questions about. A little bit about compliance with the AGCO. There's two things that go hand in hand, and one of them is risk-based compliance, and the other is risk-based enforcement. So I'll give you the high level about risk-based compliance as far as risk-based licensing goes. So these are a couple of practices that the AGCO does. There's always some risk attached to the sale and service of alcohol, and the Alcohol and Gaming Commission recognizes that sometimes it may be their type of business, sometimes it may be their location, it could be the past history of that licensee or the establishment, it could be the experience or lack of experience of the person running the establishment, things like that. But because of those things, there are some establishments that are posing a greater risk to public safety and the public interest, and or to non-compliance with the law. So a few years back, the AGCO implemented something called risk-based licensing, and it's exactly what it sounds like. It's licensing establishments based on risk, and they are looked at continually, especially again with those things in mind, the type of business, the infractions, and then they are assessed under risk. And this is for anyone who gets a new license or a transfer. It doesn't just happen when they just get their first license. It keeps on going. So it affects the transfers, the changes. So they are based on the amount of risk. It can be the type of establishment. Again, those are the risk factors, the type of establishment, the location, the history, experience, and things like that. The other one is risk-based enforcement. It is much the same, but it is how our regulating takes place as the regulator. That risk-based enforcement, or what we call RBE, we love acronyms. It was established in 2006, so it has been in force for a while. And again, it's the philosophy where the liquor compliance strategies are based, because again, we're talking resources of the AGCO. Where should the AGCO, as a government commission, decide to put their resources? All right, as taxpayers, you know that you want to see the tax money going where it should go, and the AGCO knows that and looks, okay, where can we best put our resources? We will put our resources on risk-based and judge the, or I shouldn't say judge, but look at the establishments based on risk, and that includes the enforcement. So through the effective placement of our resources, we work with our community partners. Our goal is to ensure public safety. So we want to put our resources where they're going to make the most benefit. And that's where risk-based enforcement came from. It focuses the application of the resources. We want to encourage compliance of the licensed premises that present the greatest risk to public and the communities. And when we're talking about inspections, and I know I've mentioned, yes, we are the regulator of the industry, but we want to make sure that the message out there for not only those of you who are working in the legal field, but also those licensees, and I tell them when I'm out there, our objective as the AGCO is not to go and get you. That's what I say to the licensees. Our objective is not to get them. Right? And then, you know, sometimes for years and years and years, maybe there could be that kind of thinking when it comes to any policing, so they'll get them. It's, as I say, our as an agency, main objective is voluntary compliance. And that is the main objective of the AGCO, not to run out there and get people and catch them at everything. Sure, it's going to happen. There's going to be infractions, but it's not our main objective. We know that most licensees, and this is very important to understand, most licensees want to comply with the law, right? And we, as an agency, want to provide the tools to assist them in complying with the law, which again is basically what I'm doing, going around the province doing seminars on the liquor laws. We provide information and education and training and refreshers to keep them up to date on the new laws, to refresh them on the old laws, what is, what isn't legal, things like that. We know they want to comply. They come out to the seminars. We do them for absolutely nothing. So we get a because they want to be compliant and they want to do it voluntarily. Yes, there is administrative action. We have to have administrative action as a regulator, right? There's disciplinary action. I'll go through that a little later on, but the main purpose behind administrative action is, again, to achieve voluntary compliance, so that, you know, hopes that a licensee who is on the receiving end of some administrative action says, well, I'm going to make sure that doesn't happen again, right? Oh, I got my license suspended for 7 days because of an action maybe of a staff member or something. Okay, I'm going to change things and I'm going to have a monthly staff training and refresher. Things like that. That's what we want to happen. That, okay, we've got administrative action, but we want you to take the high road now and be voluntarily compliant. That's our main objective. We're talking about responsible alcohol service. These are the things that the licensees know, and they should know, we hope. In order to achieve that voluntary compliance, they must practice responsible alcohol service. That's the name of the game. And to know these things, that first of all, you cannot serve a person as a licensee or a staff member, someone in the industry. You cannot serve a person who has had too much to drink, you know? I think we've all been in a bar at one point in time and you've seen someone come in and you know maybe they've had some drink somewhere else and then they get served. Well, they're serving somebody who's already been drinking. That is illegal. As somebody who, you know, you get off work at 2 o'clock and they're still there at 10 o'clock and they've been served to the point of intoxication, that cannot happen. That is against the law. An intoxicated person cannot enter the premises and cannot remain on the premises. And that's the way the law is. The AGCO, as you know, we do not make the laws. But the licensees always ask me, well, if somebody's been drinking somewhere else and all of a sudden they're in my establishment, what happens? Well, short answer is be proactive and don't allow them into the establishment, because you really don't want to say what happens now, right? To say, what do I do now? Well, hey, the barn door is open and there goes the horse. The thing is to be proactive for everyone in the business to know that they cannot have an intoxicated person on the premises. It goes, we're going to open the floor for questions in just a couple of minutes. If you want to write it down, hang on. And I don't want to go too deep into it, but basically that's the way the law is. And that's what we try to impress upon the licensees, that no, you can't have an intoxicated person on the premises. If they did pre-drinking at home, if they did drinking at a couple of their establishments, and now they've been sitting in your establishment for 20 minutes and they're totally intoxicated, you could be responsible for them. That's the way the law is at the same time. So that's the thing. And the public, as we know, the public are not aware of all the laws. So it's even more important than the people who are in the industry know what the laws are. If you went up to somebody, maybe a relative or whatever, that doesn't know the liquor laws and say, you know, is it legal to get drunk in a bar? They may say, yeah, where else would you go to get drunk, right? That's like the public opinion, and it always has been. Well, why is it illegal to get drunk in a bar? That's where you go to get drunk, isn't it? And that's part of the double-edged sword, is that the public may not be aware that it's illegal for them to get intoxicated. It's illegal for them to be intoxicated public, period, right? That's also a breach of the law, but not under our jurisdiction. So it's really important for us to have the licensees and the staff impress upon that on the people, because they're putting the licensee's license in jeopardy. All of the door staff of every establishment are required to do two things. Number one, they have to be licensed. They have to have a security license. That's not under us, that's under a different ministry. Under us, not only do they have to be licensed, they have to be smart serve. They have to have server training, the same as the servers, so that they can recognize the signs of intoxication of anybody who comes to the door, because they're on the front line. They're the door staff. That's where it can end. The problem can end right there when they turn away people who they believe are intoxicated. When it comes to certification, as I mentioned, they have to be smart served. If you're not aware, I'm sure you are. Smart serve is the server training program that is recognized by the board of the Alcohol and Gaming Commission as the server training program that everyone has to be certified in to work in the industry. There are probably a lot of other programs out there, but Smart Serve is the only one recognized by the Alcohol and Gaming Commission. We do not run Smart Serve. It is a private company, but it is the law that all servers, bartenders, wait staff, security, managers, anyone involved in the industry, licensees, be Smart Serve trained and certified. Just so you know, when we're talking about the Liquor License Acts, and I mentioned that every few years the government looks at it and makes a change to it. There was a few changes made back in 2007. And I'm always surprised as I go around and licensee, I didn't know that. And I'm like, well, it changed like 2007. You didn't know the law changed way back then? Well, I'm glad I'm here. Minimum drink pricing changed for them, so they can do drink specials. Again, some licensees could go down the wrong road when it comes to minimum drink pricing, because they are allowed to do specials. You can sell a 12-ounce beer, a 5-ounce glass of wine, or 1 ounce of spirits for $2, including taxes. That's the lowest price. Of course, if they do that all the time, they're not going to be a licensee anymore, because they're going to go to business, right? So they usually just, do that as liquor specials. So just you're aware of what kind of laws we have in Ontario when it comes to pricing and promotion, that they are allowed to do that. And they can also give away a complimentary drink, but not all the time. Again, if they want to stay in business, stop giving away your alcohol. But that was a change in 2012, where before that you couldn't give away any alcohol. Now they're allowed to give away a complimentary drink under special conditions, where it has to be a special occasion for the patron, just so you know. So they can't do it en masse. They can't buy a round for the house. Like next year when the Leafs win the cup, they can't buy they can't buy a round for the, I have hope. They can't buy a round for the, it has to be a special occasion like a birthday or anniversary, and they can only do it like one at a time, right? So somebody's celebrating something like a divorce or whatever. Just so you're aware of the laws when it comes to the alcohol for the licensees. Now, we're going to do a few pop quiz questions and then take a break. You've all got one of those. We're not keeping track of this. This is just for fun. You've got those little white clickers on the table.
Did anybody not get one?
Did anybody not get one? Just kind of like, okay, you've been listening to me talk for the last hour and a half or so. What exactly was this guy talking about? It's just a kind of a little self-test. What do you think? You can't see the top of the screen, but the question would be, and all you have to do is push the answer that you think it is. My laptop will pick it up here. In what year was the Liquor License Board of Ontario combined with the Gaming Control Commission to form the AGCO? Was it 1989, 1992, 1998, 2001, 2005? And all you have to do is hit your little number. I can tell how many responses are coming up on my computer. We'll see how you did. Again, this isn't a test. It isn't being sent off to the association with your names. We're not keeping it. It's just kind of like, okay, I've been talking the last hour and a half. What do you remember? Do you remember any little tiny points? There you go. Absolutely. Okay, I've got 47 responses, going once, going twice. Polling is closed. There's our replies. 1, 9%, 2, 0%, 3, 74%, 4, 4%, 5, 13%. What's the answer? 1998.
They are paying attention.
All right, 74%. That's good. How about this one? The AGCO is responsible for regulating the Liquor Control Act. Is that true or is that false? I had 47 responses on my first one. I'll look for 47 responses again. At least. And then we're going to take a break. Oh, 48. Excellent. Welcome back. Okay. Oh, split vote, split vote. 42% say it's true. 58% say it's false. That's interesting. Which one is it? It's false. It's the Liquor License Act. The Liquor Control Act is over those who are actually selling the commercial alcohol. So we're looking at the the LCBO, the Liquor Control Board of Ontario. They operate under the Liquor Control Act. We're under the selling and serving side, which is the Liquor Licensing Act. And one more. The AGCO performs which of the following duties? Do we issue liquor sales licenses? Do we administer disciplinary action? Do we perform inspections? Do we promote responsible alcohol service? Or we do all of the above? Now this was a fast one, and I'm hoping I know why. 2% says number 4. 96%. Hey! And here's one more. We're gonna put you in a situation. Here's a situation. At 3:30 in the morning, okay, 3:38 in the afternoon, an inspector walks into Tacos and Tequila Palace to conduct a routine inspection. Outside of the establishment, the inspector observed a sign which advertises Wednesday special, 20-cent wings and $1.99 beers after 4 p.m., taxes not included, no reservations, first come, first served. That's what the sign says outside. So, is this a breach of the advertising guidelines? Is this offering liquor less than the regular price? Is that an infraction? Is it that infraction? Is it both 1 and 2? The licensee is both breaching the advertising guidelines and offering liquor less than regular price? Or are there no infractions here to be found? Are they doing everything okay? Just judging by what I've said in part number 1 here. So what do you think it is? I notice the responses are not coming as fast as the last one. So we got the sign, it says 20-cent wings, $1.99 beers, after 4 p.m., taxes not included. All right. Oh, we're all over the map. So we've got 8% believe it's a breach of advertising guidelines. Okay. 27% offering liquor less than regular price. 31%, both 1 and 2. The licensee is guilty of doing both of those things or alleged to be guilty of doing both of those things. And 35% say, hey, there's nothing wrong here. No infractions. And here's why. The 31, 27, and 8% of you are going, what? The $1.99 beers after 4 p.m. say taxes not included. The minimum drink price, as I mentioned, is $2 including taxes. So once the taxes, it's not a trick question. So once you add the taxes in, it's going to go over the $2, right? Yeah, exactly. And it's all in the advertising. I was coming across, as I mentioned, sometimes I will go out and I'll do a seminar for a specific licensee who has a lot of staff, wants me to come in. And the one time I thought, okay, this was in another city. I'll go to their website and just kind of look at, where I'm going and get familiar with the place. And as soon as I opened up the web page, right on the front page, it had a picture of a draft and it said, $1 drafts. And I thought, oh my goodness, I'm going somewhere where I'm going to do a seminar and their webpage is saying you can get a draft or a beer. It said $1 beer, but then it said in small print, 6 ounces. Which can be done because the 12-ounce beer is $2. The 6-ounce can be $1. So there's the no infractions found. So what we're going to do now is let's take a 15-minute break. And we'll come back and I'll see you then. It was a very pleasant Okay, welcome back. We're heading into part 2 of our presentation this morning. As I mentioned there in part number 1 and earlier, we are going to be opening up the floor for questions. Okay, I was talking to a few people during the break there. I know there's always all kinds of questions in that, which is great. So we're going to open up the floor for questions after this. So the information part of part number 2 is not as long as part number 1, so that we can open up the floor and get questions from those of you who are watching.
Okay, so the first category then would be permit drunkenness, and I'm going to read it to you exactly as it's written, and then we'll talk about it a little bit more, okay? So the licensee must not permit drunkenness on their premise, and that's OREG 719, section 45, subsection 1. And the licensees must not serve or allow service of liquor to a person who is or appears to be intoxicated, and that's the LLA section 29. So the first one, permit drunkenness, as we've spoken about before, you cannot be drunk in a bar. So you cannot be anywhere in the premise and be drunk, and that is the licensee's responsibility to make sure that, so the licensee and their staff, their security, to make sure that no one is just in the bar, and whether that's by not letting them enter in the first place if they already appear to be drunk, or if they're in the bar, they've had too much to drink, and they need to make sure that they find them a suitable way to get home. Make sure they're not driving, call them a cab or whatnot, but they can't stay in the establishment and be drunk, okay? The licensees must not serve or allow service of liquor to a person who is or appears to be intoxicated. So that infraction in itself could be 2 infractions, because it's 1, permitting drunkenness, and it's 2, continuing to serve that person who already appears to be drunk, whether they got drunk in the establishment or whether they came from somewhere else and were already drunk. So that's permit drunkenness and serving intoxicated.
So when it comes to their training, they are all trained, and I say they, everyone who works in the industry. I mentioned this before under the server training. They are all trained with SmartServe to recognize the signs of intoxication. That's part of the SmartServe course. And this is what they are trained in, right? That signs of intoxication, this is what we call the top 10. Okay? They may not happen in this order. They don't happen one at a time. They may happen in groups. But the things they have to look out for is someone having inappropriate speech volume, talking too loud, whispering like there's a conspiracy going on all of a sudden, and there's not, right? Their pace of speech, they speed up, they slow down, they slur their words, poor enunciation, we know that one. Deterioration of gross motor control, be looking for people who are all of a sudden bumping into tables, bumping into walls, or their fine motor control starts to deteriorate. They have problem picking up change off the counter. They slam the glass down because the table was a lot farther away a minute ago. They notice that they're tired, and we've heard from some servers and that all of a sudden they'll find somebody sleeping at the table. Okay, something to look for. Their alertness decreases. They're taught that if they're asking them questions, and that's one of the things in server training is to talk to their clients to find out things, talk to the patrons, and you may notice a decrease in alertness, that things aren't firing as they should. If they have got red or glossy eyes, if they're excessively sweating and it's not 36 degrees Celsius in the room and they didn't just run a 5K marathon. And to compare their breathing with their patrons. If the patron's breathing fast and shallow, could be a sign of intoxication. I do want to mention that yes, they are made aware of. Just because they notice one of these signs doesn't mean someone's intoxicated. So if we're looking at the legal side of it, it's not a slam dunk that somebody has red eyes. They could have allergies. They could be working out in the dirt and the dust all day. So it's not that they notice a sign of intoxication. Oh, you're done, get out. Or we come in, oh, well, that person has red eyes. That's an infraction. They actually know that, all right, they need 3 signs. That's what they're trained to do. To notice when they see 3 signs of intoxication, then it's time to have that page. And the 3 signs does not mean someone is now face down on the floor, okay? That's way past 3 signs. They know they're approaching intoxication, and then to have the patron removed. That's what their training is. Ashley?
Okay, so service to minors. So as we all know, in Ontario, you must be 19 to legally have or consume alcohol. And the Liquor License Act kind of breaks it up a little bit based on whether I know this person is 19 or based on whether this person appears to be 19, okay? So Liquor License Act, Section 30, subsection 1 and 3 is based on knowing that this person is under the age of 19, whether that be just checking their ID, seeing that they're under 19, and still serving the person. Section 30, subsection 2 and subsection 4 is that this person appears to be. So I could go into a bar, see someone who looks very youthful, and they don't have ID on them. The bartender's still serving, they have no ID, so they have no way of knowing, that this person's 19 or not. But if they look very youthful and they're unable to prove that they are of age, then it could be an infraction as well, still continuing to serve that person. Just something to note is that minors are permitted in bars, in clubs, in whatnot. They are allowed to be there unless it's specified as a condition on the license or on the permit that they can't be there. Sometimes establishments have their own house rules saying no one under 19 or no one under 21 or whatever the age may be is allowed in this establishment, and they are allowed to do that because it doesn't contradict anything in the Liquor License Act. So that's just a house policy for that particular establishment. But in general, people are allowed under the age of 19 to be in the establishment. So it becomes the onus of the bar staff, and everyone else to be checking the IDs or to be making sure that people have ID on them when they're serving them.
Great. Thank you, Ashley. So when it comes to the legal drinking age, yes, the licensees and the staff are trained in that, because sometimes there may be confusion on the staff level, because as Ashley mentioned and what is up there and was on her screen, that they are allowed to work in the industry at the age of 18 serving alcohol, which says, well, why? I don't understand that. Why they're 18? Why aren't you supposed to be 19 to be, have anything to do with alcohol? But there's where the division is, that they have to understand that, yes, they can. That goes from the Liquor License Act. It's transferred over into a Labor Law Act. So they're allowed to work in the industry when they're 18, but they can't drink. So they are taught that, yeah, you cannot serve anyone under the age of 19. It's a business decision whether they let someone in or not. That's up to the business. That's why you see lineups at nightclubs after 9 o'clock on a Thursday or Friday night. They're checking ID because their house policy is we don't want anybody under 19 in the establishment, then we don't have the hassle of looking for minors. But you go into any family restaurant that's licensed, yeah, there's minors in there, as Ashley mentioned, they can be there. The other thing that the licensees and the staff are trained to do, and especially when we're talking about places that hold special events like weddings and big family dinners and that, is to be on the lookout. If they allow people under the age of 19 in, make sure drinks are not passed to them. Make sure they're not passed to them at the family events. Make sure they're not passed to them like in a restaurant or bar in the washroom, right? Because washrooms can be licensed now. They can license the entire establishment, so that may happen. So the licensees and staff are made aware of this when it comes to the legal drinking age. It's that, okay, if you're going to allow people under the age of 19 in, make sure you're very diligent on A, who's being served, and B, the people who are in the vicinity that could have drinks passed to them. The last thing I mentioned up here is the handling, and this is maybe just an FYI, the way the law works that a lot of people may not know, is that as Ashley mentioned, in the regulation, it does stipulate you must be 19 years of age to have or consume alcohol, which means that the people who are working in the establishments, if they're going to do anything with alcohol, even if they're going to carry beer over and stock the bar, they must be 18 years of age or older in that establishment. In the real world, anybody under 19 cannot handle alcohol. So people have actually been asked to leave the LCBO because they allowed their children to bring liquor up to the cash that they're under 19. But in the alcohol world and serving alcohol in the bars, they are allowed to do that at 18. Ashley?
Okay, so disorderly behavior. A licensee and staff must not permit unlawful gambling, riotous, quarrelsome, violent, or disorderly conduct, and that's OREG 719, Section 45, subsection 1. Permit the sale or use of narcotics on the premise, OREG 719, Section 45, subsection 2. And they must also ensure that reasonable methods are in place to deter disorderly conduct from occurring on the premise, occurring on the property adjacent to and in the vicinity of the establishment. So there's a bunch of infractions there, so let's just take it back a little bit. So permit unlawful gambling, fighting, use of weapons, anything of that sort, violent or disorderly conduct. Permit the sale of narcotics, that's a separate infraction. And then the last part there is a separate infraction as well, and that's also for like the parking lot directly, adjacent to the property, maybe the sidewalk in front or the areas at the side. So you can't just, push somebody out of the establishment and say they're no longer your responsibility. You are responsible for them in those adjacent areas as well. So to have security at the door and stuff like that, just to make sure that they're keeping an eye on that area as well. Yeah, I think that's it.
Thank you, Ashley. So how do we help out the licensees and the staff when they're trying to figure out how to maintain order? And as you saw on the previous slide that Ashley had, and she mentioned, there's a lot of different things in there. There's a lot of possible infractions. There's a lot of possible breaches of the Act, all under Section 45. So what do we do to help out the licensees and the staff? What should they know? We make sure that they know they have to run their establishment in an orderly fashion. They cannot let things get out of hand. And as Ashley mentioned also, that includes the area surrounding the establishment. Some things that some licensees may not know. It was added into the Liquor License Act a few years ago called reasonable measures, where, for instance, if I had a bar on a main street and I had a lineup of people going down the sidewalk waiting to have their ID checked to get in, technically they are going to be, they're my patrons, and I have businesses beside me. A fight breaks out in the lineup, planter box gets thrown through the window next door of a neighboring business. I may be responsible for that because I didn't take any reasonable measures just by having somebody out there making sure that, disorderly conduct didn't happen. I didn't do that. So I may be held responsible for that. So again, that's one of the things that we make sure that the licensees know, that the responsibility now doesn't stop at the front door. And any illegal activities, again, they're encouraged to monitor. Even though, you may ask some licensees or whatever, oh, do you think your patrons could be doing illegal activities or, maybe doing drugs in your washroom? And they'll, oh, no, not mine. But you never know, not my patrons, not at all. But we don't know. we never know about other people. So they're very encouraged that it doesn't matter who the patrons are, what kind of establishment you have. Do a sweep in the morning when you open up, check the washrooms and that, because somebody could have left something in the washroom the night up. There could be a deal that went down that they didn't even know about it. We've all seen The Godfather, right? I doubt if they're going to find a lot of guns taped at the back of the toilets like The Godfather, but we're just saying is that check those areas that you may not think of checking, so that, you know, it doesn't get found by someone else who says, hey, maybe there's some illegal activity going on here. So those kinds of things are the things that we impress upon the licensees and the staff, that, again, we go back to, it's your responsibility to make sure that you don't become liable.
In overcrowding, so each establishment would have a set capacity, and that would be set by the fire department or building. And once that capacity is set, they must adhere to that capacity. And one thing that we always mention is that the capacity has to include staff members. So not just the patrons in the establishment, but you need to say, if you have 10 staff, you need to include those people in your count as well. So licensees must adhere to the capacities of the liquor license. OREG 719, section 43. Capacities are issued, as I mentioned, by the fire department, the municipal building licensing departments, and the Alcohol and Gaming Commission. And licensees cannot combine their license areas unless specifically stated on their license. So sometimes an establishment may have separate capacities for separate rooms, or the patio might have a capacity and then inside has a capacity. You cannot combine that into one capacity. Each capacity is treated separately. So keep that in mind as well. And then, as I mentioned, just make sure you're including the staff, because your staff that night might put you over capacity. So just make sure of that as well. Pardon me?
Staff go in and out of rooms to the staff.
So it's, as I said, like the staff who stay like in the kitchen, behind the scenes, whatnot, they wouldn't necessarily be considered in the capacity, but serving staff who are moving around, they are included in the capacity.
Thank you, Ashley. And as I mentioned, that is, and that's a good point you bring up, is the clarification of the capacity. What is it? And again, this is what we impress upon the licensees, is that, you know, your capacity is there. Make sure your door people know it. Things have changed, right, in the years. And because I can only look around this room here and not at home, but I know people here have been in, could have gone to establishments years ago, and, you know, smoking was in there and nobody went outside for smokes. Well, once you went into the establishment, you were there, you know, until you decided to leave. But now, with people going in and out for all kinds of different reasons, their capacity will change all the time. So it's very important for them to keep track of that and to count in their staff at the same time, because the maximum capacity, as Ashley mentioned on the license, includes staff. It's a body count. It's not people drinking. That's not what the license says. It says maximum capacity, so it means the number of people there. Because of the fact, again, we go back to the public interest. It's important that the licensees know that, you know, if you say, well, you know, is it really a big thing in the law if somebody's, you know, what, 10 people over? It is, because of the fact of the public safety. That's the aspect. That's the legal aspect, and the importance of the capacity is that it is a danger to the public. It's a very serious offense. We've all heard stories in the past about, you know, a fire starting, people getting trampled because there was far too many people in the place. That's why. So the licensees are told to keep that count, have the door clickers, do a count all the time, because that's what our inspectors do when they walk in and see a lot of people in an establishment.
Okay, so hours of alcohol service. Hours in licensed establishment in Ontario, so that's Monday to Sunday, 11 a.m. to 2 a.m. Sale of alcohol stops at 2 a.m. and then they have 45 minutes after that point to clean up all signs of alcohol service. So that's just like beer bottles, any glasses that were being used, all that has to be cleared within 45 minutes. So by 2:45. There are exceptions, so that being New Year's Eve, which it's extended until 3 a.m. And at that point, they once again get the 45 minutes. So all signs of service have to be cleared by 3:45. And there may be conditions on the license which limit it to earlier than the 2 o'clock, but that the licensee would know that because that's on their liquor license. Yeah.
Thanks, Ashley. Yeah, pretty basic, the hours of alcohol service. I mean, the actual fact in the law is pretty basic, but, you know, there's always, sometimes they go around that. So again, we impress upon the licensees and the staff to make sure that you're selling and serving only from 11 a.m. to 2 a.m., with the exceptions that Ashley mentioned, you know, New Year's Eve when you can delight your staff and make them stay for an extra hour. Daylight savings when the clock goes back, sometimes that's confusing for them, because it hits, you know, the 2 o'clock and then it goes back to 1. They are allowed to serve for that extra hour. It's not illegal. And the AGCO approved extension of hours, such as when the World Cup is on and somebody wants to broadcast the soccer games that are happening in a different country, can they extend the hours? That's with the approval of the AGCO. Although there have been licensees in the past that extend their own hours by themselves, which is, you know, they start at 10 o'clock in the morning or something, which is illegal. So it's very important that they understand they can only sell and serve till 2, and all signs of service have to be off by 2:45. Just so you know, if a licensee ever asks you this question, because I do get it a lot, if say they're in a small town, not necessarily that, but it would probably happen more in a smaller community than a larger one. And we've got a winter like we had 2 years ago, and there's absolutely nobody on the street at 11 o'clock at night. Does a licensee have to stay open until 2 a.m.? The answer, no, it's a business decision. They can close earlier than 2 a.m. That's up to them. But I do get that question a lot, especially 2 years ago in the winter that we had. It's the limit. That's what 2 a.m. is. No serving past that. So if they want to close earlier, that's okay, just in case your licensees ask. The thing on the screen that says licensees or employees cannot pre-sell the alcohol and place it on ice, what that means is it used to be, I'm not going to say a common practice because I don't know if it happened everywhere, but it used to be kind of a practice back in the wild and crazy 80s. And maybe it still happens today, where somebody will order mini drinks before the 2 o'clock and then want them left in the cooler and then delivered after 2 o'clock. So I'll pay for it now, and maybe you've experienced this. Okay, yeah, that's familiar, isn't it? I'll pay for it now, and then, but don't let them get warm, you know, deliver. But so the licensees and the staff have to know that that's called placed on ice. That's called pre-selling, where, hey, if it goes through the cash, it's okay. It's not. The service has to end at 2 o'clock too. Oh, sorry, Ashley, there we go. I took your slide away. Oh, that's your big fun, is it? No, removing signs of service. That's part 2 of that one.
Okay, so as I mentioned, just removing signs of service. We already kind of spoke on this. It's removing it off the tables, off the, let's see, the patio, the DJ booth, washrooms, anything like that. Obviously, they're not going to remove alcohol from behind their bar. That's fine. But any, you know, bottles that are already open, glasses that are being used, anything like that, patrons can't be seen holding the glasses that they're still drinking from with alcohol in it after 2:45. So all those have to be cleared, and that is a separate infraction from selling or serving after 2. There's just an infraction for failing to clear all items after 2:45.
Okay, thank you, Ashley, for helping out in that section and giving the regulations and the inspector's point of view from that. So just to recap the big 5 that we have, they are permit drunkenness, selling and serving to minors, disorderly behavior, overcrowding, and selling and serving outside the prescribed hours. And that means either early, you know, usually we're talking about after 2 o'clock, but also they cannot serve alcohol before 11 o'clock in the morning. And also failure to remove the signs of service. So as I mentioned, those are the big 5 concerns when it comes to public safety. These obviously are not the only possible infractions that a licensee could face, but as you look at the list of, you know, permit drunkenness, sell and serve to minors, disorderly behavior, overcrowding, and serving outside the hours, you probably would agree that, you know, maybe those kind of things may happen more than other things. So those are the definite ones that our inspectors concentrate on. So we're jumping into something different, something called a letter of incident. We're going to look at the letter of incident and hearings, okay, our quasi-judicial hearings. We'll look at the liquor side of things. A letter of incident when the AGCO receives information that indicates one or more violations of the Liquor License Act and the regulations may have occurred in a licensed establishment, and where possible further action is required, then that licensee is sent a letter, and it's called the Letter of Incident. And because we like acronyms, we also call it the LOI. What the LOI or Letter of Incident states are the possible sanctions that may be applied. And I've mentioned a couple of times so far this morning that, yes, there is administrative action, there can be sanctions. This is where it comes in. There are possible sanctions that can be applied or will invite a response from the licensee by a date that is approximately 15 business days from the date of the letter. So when the licensee receives the letter, they are allowed to respond to whatever is in that letter of incident. So in the written response, the licensee can also provide information. In other words, what we're saying is they get to tell their side of the story. They can provide us information and materials before the deputy registrar makes a decision. So this would be a possible tree on what would happen. So, okay, we have the top alleged infractions are reported to the AGCO. Okay. The initial review of allegations undertaken. The letter of incident sent to the licensee that outlines possible allegations and potential compliance options. And at that point, as I mentioned, and it's very important to remember this, that again, we're not talking slam dunk. We're letting them know that there's possible infractions here. The licensee is given the opportunity to respond with their side of the story within that 15-day period. And then the process continues with the deputy registrar considering the licensee's response, if there is any response from the licensee, and determines any administrative action. So what can they do? When it comes to administrative action, the registrar has the options of taking no further action. Maybe the registrar has the information from the licensee, information on the allegations, and decides not to take any further action on it. A warning letter can be issued. Assessing monetary penalties is also an option. And again, I go back to, don't forget, voluntary compliance. Voluntary compliance is what the AGCO is looking for. So that's why there are a lot of options here that can happen. A monetary penalty could be assessed. The registrar can propose risk-based licensing conditions on the license. I don't know if you're familiar with what conditions are, but again, you have a liquor sales license for an establishment. After a hearing, or if the registrar wants to put conditions on the license, they're allowed to do that. And when it comes to conditions, it's not a matter of opening the big book of conditions and looking at which one applies. They can be customized for that establishment to find a solution to mitigate the risk. You'll notice that some establishments, for instance, have plastic cups on their patios and nothing else. That may be a condition on their license. It may be something the licensee wants to do. But sometimes that is a condition that's put on a patio license, that only plastic cups can be used there. So there's all kinds of different conditions that can be put on a license by the registrar. They can propose, of course, to suspend a liquor license. The registrar can put out that, all called a notice of proposal. They can also send out a proposal to revoke the liquor license. That would be, of course, worst case scenario, take the license away. And they can also, the registrar can impose an interim suspension. And an interim suspension doesn't happen every week. That would be an incident where something major has happened, so we'll suspend the license right now and find out what happened. From personal experience at the AGCO, the one incident I do remember was when it was reported that a shooting had happened in an establishment. I can't remember the exact details, and it doesn't matter, but that's where an interim suspension would come in. Okay, let's halt action and have a look. So that can also be an option for the registrar. So once the licensee received these, the administrative action and the proposals, they can appeal. They can appeal the registrar's notice of proposal, or their order of monetary penalties by requesting a hearing. And a hearing, of course, will be before the License Appeal Tribunal, or as we all know it as LAT. Now, when they get that administrative action, now obviously, if it's decided by the registrar to take no further action, there's nothing to appeal. But let's say they got a notice of proposal for a suspension of the license. They want to appeal it. They have that 15-day window to make an appeal. When it comes to the License Appeal Tribunal, if you're not familiar with LAT, I'm sure you are. It is an agency of the Ontario government that's responsible for the adjudication of matters involving licensing activities, regulated by the various ministries. So, you know, the License Appeal Tribunal is not part of the AGCO. It's the other way around, where the AGCO is a licensing commission. So we would have our hearings done at LAT. And so do all other, you know, licensing agencies. So they also look after liquor matters. So when it comes to the hearings, there's two types of hearing. Number one is a public interest application. That would be where someone has made an application as far as a liquor license is concerned, a licensee, and residents in the municipality can object to that application. And it could be an application for a new license. Remember, we used to see those in the newspaper where somebody's applied for a new license, and if you have any objections or whatever, you write into the AGCO. It could be an objection for an application for a patio. Maybe residents in the neighborhood don't want an outdoor patio. Or maybe they're just objecting to an increase in a capacity, right? Increase in seating capacity. So once the applicant or the licensee makes an application to do something with their establishment, then it would be posted. Public notices are posted by the AGCO. They're on our website, and a placard, big square sign, is posted at the premises that this is what the premises are intending to do. You as the public have a right to weigh in and tell us what you think. So that may go to the public interest hearing if it goes that far. Some things can be solved earlier. The second type of hearing would be a disciplinary hearing. That, of course, are when there are breaches of the Liquor License Act and the Gaming Control Act for the gaming side. But right now we're just talking about the Liquor License Act. And of course, as I mentioned, the licensee can request a hearing to dispute that notice of proposal or to dispute that order of monetary penalty that has been issued by the registrar. They must do it within 15 days. Okay? If they want that hearing to dispute it, they have to have it into us within 15 days. Otherwise, the notice of proposal will carry through if they don't hear back from the licensee. So in a nutshell, that's basically how our hearing systems will work. Of course, a little more intricacies when we're talking about the public interest hearings, that type of thing, but those are the two main ones, and they are done at the License Appeal Tribunal Board. Oh, it's quiz time. We're going to do a few more questions, and then we're going to jump into our question and answers from in the room and from at home. But if we have your little clickers here in the room, which of the following is one of the big 5 infractions? Serving minors, overcrowding, 3 after-hours service, permitting drunkenness, disorderly behavior, or all of the above? $37, $38? I know you said 47. Not sure if we have 47 now. We're almost there. While we're waiting for our final few answers to come in, we're not quite where we were. Just a reminder, when at the end, the little clickers, just leave them on your chair on the table. We'll collect them. They don't work on your DVDs or can't use them to open the garage door on the way home. They only work on our voting technology. Okay, let's see how we did. 96% said all of the above. And it's all of the above. Yes, all of those are our big 5 infractions. Maximum capacity of a licensed establishment does not include staff, and it does not include babies. Is that true or false? Okay, let's see how we did. 4% said 1. It's true. No babies go out. 96% said number 2, and it is false. Yeah, it includes everyone, whether regardless of age. Yeah, it includes babies as well because it's maximum. Again, it's not maximum capacity of people drinking.
They're still people too.
They are still people too.
Little people.
They're little people, yeah, but they're. Which of the following is not a sign of intoxication? Is it excessive sweating? Which one is not a sign? Increased use of profanity, slurred speech, or inappropriate speech volume? Which of those is not a sign of intoxication? Okay, let's see what we did. We're all over the map? Oh, pretty much number 3. Okay. Yeah, increased use of profanity is not a sign of intoxication. I'm not going to say how many people I know that use increase of profanity when they drink, but that's not necessarily a sign of intoxication. Nor is somebody who keeps saying, I love you. It's not necessarily a sign of intoxication. Okay, so we're going to open the floor for questions from here. I know we do have some questions that were sent in from those of you who are watching and joining us on the web. And we do have someone who's going to ask those questions on your behalf. The questions are not just for me alone, for our entire panel. Inspectors, Tanya, our manager. So do you have any questions right off the bat or questions that were coming in? Over here? I always do. Not a problem.
When there's a license being transferred, you said that somebody can contract out in the meantime. Can I get an example that I
Okay, the question is dealing with licensees and having their establishment selling, and you're looking for an example of the contracting out and what that means. Okay, just a little bit more detail on it, that's fine. I'll just give you a theoretical one as far as I own the, but I'm selling it. Ashley wants to buy my business. Liquor is not mine to sell and go with the business. So I say to her, well, why don't we apply to the AGCO and we will have my license transferred to you. Think of the old days when you were buying a car. Only a little different because you're talking liquor sales license. So, all right, I give Ashley approval because it's my business to apply to the AGCO for a license transfer. The agency says, okay, we're going to send that out. That's okay with Mark. He's fine with contracting it out. They send me a certificate, or it's not really a license. It just says it's an authorization to contract out. That now goes on my wall in the establishment beside my liquor sales license. So the inspector, when they come in, they know that there's a business deal in process. So I'm contracting out my business. Also, the inspector knows that since I'm contracting it out, we're both responsible for everything, myself and Ashley. Forget about the business deal. We're simply just talking about the license. So if there's an infraction, like when I'm contracting my business out to Ashley and we're both running the business, if there's a breach of the act and someone is serving a minor, then we both share the responsibility and the liability of that breach. And then when the paperwork and everything of transferring the license over to Ashley is done at head office, then it's totally transferred to her and I have nothing to do with it. Does that make sense? Yeah. Okay. At the back and then over here. Is there a difference between serving drinks and selling drinks? Especially, so you're saying aggressive selling? Okay. There is, if you're talking about the difference, and I could probably hand it off to Ashley or Adam in a second, but there is something called promoting a moderate consumption. And again, I'm not going to say that's exactly what it is, but it is illegal for a licensee to promote immoderate consumption. And again, I'm going to hand it to Ashley as far as, okay, an example of promoting a moderate consumption. He's talking about selling aggressively for Ashley and Adam. Is that considered that? Or what's the difference between the selling and selling aggressively? Adam?
So besides that, there's certain, in the regulation, it speaks to selling and serving. So for example, serving after hours, you can't sell after hours or serve. So in the scenario that was given during the presentation where some people purchase alcohol prior to 2 a.m. and then get it served after. So the regulation is very specific there, where you can't sell it, where you can sell it and serve it. So there's a difference between the two. So just because you paid for it before 2, you still can't serve it after hours. So there's a difference there. When it comes to aggressive selling, the licensees, they can't promote immoderate consumption, so they can't do aggressive sales tactics such as offering drinks at specials where there's a contingent on the purchase of many. So they can't do a deal, well, if you buy 1 beer for $4, or we can give you 5 beers for $20 or something like that. So they can't do sales tactics where they're encouraging patrons to buy more than one drink. So, does it make sense? Or? Yeah.
Okay, there was a question over here. There.
Another question about the transfer again.
Okay.
Cost-wise, can you tell us what the difference in the cost is and time frame of the 2 applications? Is there a big difference?
The time frame of the 2 applications, they would be approximately the same, depending on how much information we get in at what time. You're talking the difference between a new applicant and somebody who is doing a contracting out. The work done at head office would still be the same as far as the administration that they have to do. The time frame would be the same, except if it was the license on the applicant. I won't call them a licensee. If it's the new applicant that wants to start fresh and get their own license, the time frame may be changed by them getting their paperwork to us. That's the only thing that would change. What we do at head office would remain the same, because all the legalities have to be looked after as far as who owns this license, etc. But it would be, the onus would be on them getting us the letters, the compliance letters, and things like that. For a transfer, it may end up at the end of the day, the transfer for contracting out may be a little quicker, but again, it may go back to the people who have to get the paperwork and how long it takes them to do that. And your other question was the cost. I'm not sure of the cost of a transfer, because a new license is the $1,100, but the cost of the transfer,
I think it's included in it.
Included in.
So the transfer, when you apply for the application, you pay the 1 fee for the license.
Yeah.
And the transfer is just the process.
Yeah. So it'd be the same. Here.
Yes, sir. My concern is more or less to do with private parties, such as wine parties or art shows. Let's say social events, things like that. The liquor is freely served, not necessarily sold, and there's minors that you don't know who you're dealing with actually in a crowd like that. So how does this sort of control those issues?
Okay, so the question is, or your concern, as you said, as you phrased it, as a concern is with events,
right,
where they have alcohol in their private events, and there is alcohol being either sold or not sold, and there's minors at the events. And your last part was your concern would be?
How would we control it? Like,
how would you control it?
For something.
Okay, if you're talking about different events, because there's different ways of doing events, and we could talk about it for a long, long time, because it could be done under a liquor sales license. But if somebody's giving away alcohol it's probably done under a special occasion permit. You're talking like at weddings and things like that, because you can get a no sale permit.
Could also be under a caterer's.
And a caterer's endorsement, correct. So as far as how that's handled as far as control goes, I'll take it back to our panel, because it goes into responsibility and who has that responsibility.
It really depends. It really depends on where and how the liquor or alcohol is being served.
But a lot of the stakeholders
Right.
Last week, I attended a condo party. A lot of people, these private condo, there was food and there was booze and there's all kinds of people of all ages, you know, what age, 18 or 19 or whatever they were. How does that come under the control, or is that something that your authority controls?
Depending on how they're holding that party, if they are using a license or a permit to hold that party in the condo event room, or if they're just if they're holding it in their condo and if they're trying to hold the event as a private party in a private place, the rules would still apply. Minors still can't drink in those areas, so it would just depend on who would enforce those rules.
But supposing there's an infraction.
Right.
Who's responsible for that in that private party? Is the condo association responsible for that?
I mean, well, I see what you mean. So who would be it depends. It would be one with the person actually served the alcohol to the minor, and it may even extend to the person that's holding the event as well.
Have you had any experience with that?
We've had experience where we've had those problems, but they fell under the authority of a permit. So a person that lives in the condo has got a special occasion permit for that event space in a condo, and we've attended, and then we've found them serving minors, so we've revoked the permit and take action against the permit holder. But we haven't, from the Alcohol and Gaming Commission point of view, we haven't dealt with much private parties and the service of minor. That would more be adjudicated to the police.
Okay, we're going to jump over to our folks online who are sending in questions also.
We have 3 questions online. First one is, who determines high or low risk in RBE?
Who determines high or low risk in RBE? Okay, I'll drop that back to our inspectors who work with RBE. Again, stands for risk-based enforcement. So I'll drop that back to our panel, our senior inspectors, or Ashley.
Okay, so when we go and we conduct inspections at establishments, we write a report and we list the infractions that we found at those establishments. Those infractions are turned into a score. So each establishment will have an infraction score based on the type of infractions and the frequency, okay? So the higher their score is, the more likely they are gonna be to be put onto our RBE list.
So the question was so I like that's a great answer, but is it the registrar then that would determine it goes on to it, or when they hit a certain score, it automatically goes on that list?
It doesn't automatically go on. The local inspector would look at the infraction history for the establishments in their area. At that point, I would say, okay, this establishment has an infraction history, a score that's quite high, and then I fill out a form which puts them onto an RBE list. My supervisor is going to look over their history and whatnot, approve it, and then going forward, it would be put on the RBE list.
Do you want to continue with the next 2 questions?
If you've got a couple of questions, we'll do the
Yeah,
online
I've got
ones
2 more.
first, because we've had some in the room.
Caitlin's asking, if someone is using fake ID and orders drinks, whose responsibility is it to control that? And if it's the establishments, how do they screen it out, or do you have suggestions on how they can avoid that?
Okay, question is in and around using fake ID and the responsibility. Since our inspectors deal with this all the time, it's easier for me to.
Well, when we initially go out and we license places, we do give them a lot of information. We give them pamphlets, we give them what we call a toolkit, and it goes over all those things, such as checking IDs and acceptable forms of IDs. So we do provide education on what IDs are acceptable and things to look for that indicate a fake ID. So we do educate the staff. At that point, it is the staff and the establishment's responsibilities to kind of make sure they're checking ID, make sure they're looking at it properly, make sure, is this person who they say they are? It's not a brother or sister or something like that. That's kind of on the establishment.
And on the lines of ID, just so you know that there are prescribed forms of identification listed right in the Liquor License Act. And if a licensee sticks to those forms of ID to ask for, they may not have any problems. They're right in there as far as what you should be accepting as a piece of ID and the criteria.
Just on that point, does it make a difference whether the ID, for example, a driver's license is expired?
Yes.
Does that make
It should be valid.
No, I understand that, but I meant for the purposes of identifying name and age, does it matter if the ID is?
It should be a valid piece of ID.
Birth certificate?
I would hope a birth certificate is still valid.
It has to have a picture.
Oh, you're asking that as a piece of ID. Sorry, I thought we were on the validity side still. Birth certificate is not listed. There is criteria in the Liquor License Act, criteria for acceptable ID. It has to be government issued. It has to have a photograph, right?
Never does.
Right, so a birth certificate or a student card or something like that that does not have a photograph would not be asked for as a piece of ID because they do not have a photograph on it. Your driver's licenses, like I said, they're all listed in your driver's license, your passport, things like that that have your photograph on it.
It's basically any piece of identification that contains a photo of the individual, a birth date, and is reasonably appears to be issued by a government. So a university ID, when high school ID card, those types of things. Obviously, those things, but anything reasonably issued by a government that appears to be issued by a government that does both contain the photo and the date of birth.
Yeah, I'll give you one more question offline. Lori's asking, what major infractions can cause you to have your license revoked completely?
I don't think there'd be any one major infraction, but habitual breaches of the public safety infractions would you definitely then go down that path of having. I mean, it's all progressive discipline. I mean, we don't really want to take. We're not in the business of taking people's licenses away from them. We're there to do harm reduction. We're there to educate them to prevent them from putting the public at risk. But if you are constantly breaching the public safety infractions of the Liquor License Act and regulations, the suspensions are going to get lengthier, and at some point the registrar is going to say, you know, there's just no point to continue it. This person's not fit to be licensee and revoke the license.
Thank you.
Okay. Well, Open, do you have one?
Oh, I guess I'll just do one more from online. Are breaches, Gerald asked, are breaches of the Act strict liability offenses?
You're getting into liability as far as that goes? Are breaches of the Act strict? Run that by us again?
Due diligence available. Due diligence defense is available.
Due diligence defense?
Yeah, I mean, it's more a question for legal. I know that they do take your due diligence into account when dealing with the infractions, but I mean that's more a question for our legal department.
And for us.
Yeah.
And for you, yeah. For our legal department, yeah. Okay, let's go back into here and we'll go back to online in a minute. Yes.
Just on the question of how are things moving along for selling the bottles of wine and beer in the local stores like Max Milk.
So the question is, you're talking about selling beer and wine in convenience stores or grocery stores?
And grocery stores.
Different things.
Okay.
First of all, it's not under us as far as AGCO deciding when that's going to happen. That, of course, is a government directive. They are the ones that are doing that. So when you say how are things going, we know basically what you know as far as what's in the press and how it's proceeding.
It's like they have to stop selling if they're over 24 hours, and they got it in their thing that they don't have to stop selling it. It's doing loss.
Yeah, well, the press releases that I've read, and again, I'm just getting what I've read out of the news on how it's going to operate, and maybe there's all kinds of different things floating out there. And like I said, it's not an AGCO decision. Is that it will operate the same as the establishments or the government stores that are selling it right now.
So they're under the regulation of the government. Guidelines.
There's actually, I'm actually at that table. There is new regulations coming. I can't give you too much information, but it will be grocery stores and some other large stores, and it should be coming this year. I don't want. It's not that I can't give you the information. It's evolving. It's changing. So, but we are at the table, and it is coming very soon. And you'll see some regulations coming down regarding that and the sale and responsible service of sale in grocery stores or other stores that aren't LCBO and the beer store. But that will be coming this year.
Okay.
Is that from online or at
No, it's just mine.
for yourself? Okay,
My
from the
personal
room.
question is where does the AGCO come in? For example, I come from a university town, so you have students who throw a large kegger on the property where I've had clients who have 100 people come to their house at rather large properties. At what point does a private party sort of become the jurisdiction of something that would need a license? Like, for example, if you have 5 or 6 friends at a house drinking, that's one thing, but at what point does it become an issue, an event that requires licensing?
If it's a private party, it's a private party.
But there's
I'll
two
throw
things,
Tanya
right?
there.
Like,
Yeah.
in addition to the private party, anytime there's sale of alcohol, we're usually involved, right?
Okay.
So even though because technically, I mean, if you were having a private party but charging everybody $5 a beer, you're basically running an unlicensed establishment out of your residence. But so those are.
But you can serve it and give it? And in a private event? And not.
Like in a private residence, if you're like, I mean, whether you're having either where you're serving to your guests or people are bringing their own for their own consumption there, then those are two reasons.
So that's outside of the.
Okay. Let's go to the back of the room. Young lady had her hand up a couple of times. Yes. Yep.
I've had more and more often now we're seeing establishments that are offering this big bottle service.
Yes.
Is there special rules that apply to bottle service because they're putting a large bottle of alcohol instead of monitoring how much they're giving out?
Okay, the question is around bottle service, and as far as are there any special rules, et cetera, that around bottle service. First of all, just to go back on how that came about, there used to be a maximum. Now we're talking liquor sales license, not special occasion permit, but liquor sales license. There used to be a maximum amount of alcohol per drink in the Liquor License Act. That was removed, which opened the door for bottle service. And as far as in and around, a lot of licensees choose not to do bottle service because of the fact that it could be walking a fine line, and I'll pass it to our inspectors in a second to talk about that, because of the fact that, yes, you're allowed to serve bottle service, but don't forget your responsibilities under encouraging a moderate consumption. Because are you selling a 26er to one person sitting there, or sorry, a 750 milliliter bottle to one person who is sitting there, or are you selling a bottle to a group of business people? There's 15 people around the table, and those kind of things they have to look at. That yes, technically bottle service is legal, but then again, you've got that responsibility on responsible service and how you're handling that. Same as a jug, right? You can serve a jug to one person, but are you going to station a staff employee to stand there and watch them while they drink it, looking for the 3 signs? What are our inspectors' opinions?
I think Mark actually answered the question very well, that they do have to, keep in mind the promote a moderate consumption, how many people are they selling that bottle to, and then also just to be aware that they are responsible to make sure that these people aren't getting drunk. That's the permit drunkenness once again. So just keeping an extra eye on them, but they are allowed to do bottle service.
So ladies and gentlemen, we're gonna wrap it up because I know everybody's got questions and we could stay here all afternoon, but we do have to hear from our president, and I'd like to give a big round of applause to everybody from the Alcohol and Gaming Commission. And we'd just like to say thank you from the Ontario Paralegal Association for coming out on a Saturday and for your time, and job well done. Thank you very much.
Thank you very much. So on behalf of Adam, Tanya, Ashley, and myself, it was our pleasure to come out. It's always our pleasure, not only myself in public affairs, and Tanya, who looks after external stakeholder training, and of course our inspectors, to inform everyone, because the more information, then the more voluntary compliance. Before we leave, I just want to know if you could check your belongings that you have. It could be all your stuff there. We do have a couple of our clickers that are outstanding. So I know there's a lot of stuff on the tables and things like that. So if they're still out there, let us know. And we do have business cards. I know we still have some questions out there, and I know you want to move along. You have another speech to listen to, but if you want some business cards, we all have them available for you. Thank you.
Sorry.
Oh, sorry. Good. How are you?
Try now? Yeah? Okay. All right. How many people are still online? Yeah, mute it for a second.
We have a two-hander. Yeah.
All right, for those that are remaining, I just want to say thank you all for coming. The report that I was going to give, I will post on the website, and you can give an update. You'll read the update of what's been happening. Obviously, there's no point in me giving any explanation of what's been going on. We will post it, but I will ask everybody to check the Toronto Star if you can today. In the wheels section, Jim Kenzie did a third of a page article on AMPS, which is an expansion of the video that I put up on the Facebook and the website, I think it was. It was also available on YouTube as a result of a conversation that we had. He's now written another very lengthy article expanding on that video.
What day is it?
Today.
Oh, good.
I was thinking there wasn't really enough people, although we still have some online, to give my update. If you want to listen, I'll do it by all means. I'll post it up anyway, but all right. So everyone can take their seats, and then I'll continue with it. So, to give you an update of what the board and committees have been up to since our last meeting here, bearing in mind the last meeting was May the 30th. On June the 2nd, Brian, Greg, and myself, together with people from Council, PA, met with a senior policy advisor at the Ministry of Finance. Bearing in mind that's where Bill 15 originated, and they're talking about AMPS in there for commercial motor vehicles. But Bill 15 has not, although was given royal assent last November, it has not as yet been proclaimed. And our information is that they don't know when it's going to be proclaimed. You can't proclaim a bill in force until regulations have been developed, and no such regulations have even been started yet, is our information. The policy advisor was very responsive, but he admitted he had little understanding on AMPS. You got that impression too? Yeah. Even though it's his ministry that started writing it, but the amendment to the Highway Traffic Act was sort of slipped in to the Ministry of Finance bill, which is to do with insurance, reducing insurance fraud. We certainly gave him something to think about, and he wants us involved in any future consultations. Following evening, Greg and I attended a reception hosted by the Premier. There was a staff member there who has some knowledge of AMPS and had already briefed the Premier on this issue. She introduced us to the Premier, who listened to what we had to say about AMPS and remembered that her staff member had mentioned this to her, and said, "Oh yes, you spoke to me about that." Yes, she did. Obviously, she couldn't commit herself to anything at this point, but she understood our concerns, and she asked her staff member to keep her informed. The following week, on June the 9th, Greg, Brian, George, Brown, and I, together again with Council PA people, met with the Premier's senior or Justice Policy Advisor. She was very sympathetic to our position, and she assured us that the AMP issue has not as yet been brought before Cabinet and is nowhere near ready to do so. Being a lawyer herself, she had some serious concerns over the consultation document and the erosion of the right of innocence until proven guilty. Anything else that you feel that I missed on that point? That afternoon, I met with another senior policy advisor at the Ministry of the Attorney General, who had called me to ask me to come in and talk about family law. And I mentioned this on May the 30th, bearing in mind that the ministry called me on behalf of OPA to talk about family law. It's something that's on the back burner at the moment. She's made it a project for herself to put something together for the minister's attention. She hopes to get completed around August. She let me know that the minister is very enthusiastic about exploring ways of expanding the access to justice in family law and various other initiatives. Apart from ministry and AMP stuff, you may have seen on Facebook, I joined members of our wonderfully hard-working Communications and Marketing Committee to present some money to Prostate Cancer Canada, which they collected at the Aurora Street Festival. You saw that. And on June the 22nd, I accepted an invitation from the Attorney General to join her round table called Better Justice Together. It's available to look at what they would do, what sort of thing they're looking at on the ministry's website. This is part of the AG's Access to Justice programs, and this session focused on streamlining family courts and mental health issues for persons charged in criminal courts. There were 24 people around the table, not including the Attorney General, who stayed for the whole meeting. There was a Deputy Attorney General, Patrick Monahan, a couple of Assistant Deputy Attorney General, and various staff. Most of the invitees were lawyers and representatives from various other social organizations. The Chief Justices, Chief Justice of the Ontario Court of Appeal, Superior Court of Justice, and the Ontario Court of Justice, the new Toronto Police Chief. 2 presentations were made, after which the Deputy Attorney General went around the table asking for practical solutions or ideas. So it was all from the Law Society. Me. What they were saying was talking about how, from Legal Aid Ontario's point of view, they only deal with the very, very poor. And then a couple of persons down, the lawyer from another organization said people can't afford a lawyer until they've got at least an income of about $100,000. So I'm thinking, this sounds like a good segue. So I piped up and said, well, we fill that gap. Affordable, successful way of doing so. We just need an expansion of the scope of practice with appropriate education and qualifications. I pointed out that Washington State have their limited licensed legal technician, which only focusing on family law. Lots of approving nods around the table from all these other organizations. And what was more important, that at closing remarks of the Attorney General herself, she hoped that something could be done to bring those in the family courts. I feel that this is the best way to deal with this, bearing in mind that the Law Society up until 2004 had wanted nothing to do with this, until the Attorney General went to convocation and said, jump, and the Law Society said, how high? So on that basis, I've already mentioned it to other people within the Attorney General's ministry and the Law Society, privately to one individual, that the only way this is going to work is have the initiative come from the Attorney General's office directly, the same as they did in the very beginning. Bearing in mind it was them that contacted me to talk about family law, that may well happen. I don't know. Please don't hit me if it doesn't, but we're working on it. So then a couple of days later, after this, I got a personal letter from the Attorney General. It was a situation where she sent it out to all the participants with a little paragraph about their own particular involvement. But the paragraph that I want to bring to your attention is what she said is, I was particularly interested in your comments on increasing the scope of paralegal practice, particularly in the context of family law, to enhance access to justice. As I noted in my closing remarks, I intend to consider that point carefully as we move forward. So all we can do is hope and work towards it. And there'll be other consultations presumably down the road once this senior policy advisor has put her paperwork together. Maybe we can move forward on that issue. So in between all this, the board has met several times. So have the various committees, all to discuss various issues. And I want to tell you again that we've all put in many hours of our own time to make this organization a success. In the next few days, the website will provide links to sign up for fantastic rates on car and home insurance. And on that very point, we have with us the gentleman who put this thing together for us, Mr. Gary Banks, sitting at the back there, who's been very patient this whole morning. And he is here to answer any of your questions you may have. I don't know if any of you are aware of it, but we have some fabulous rates, which you'll no doubt be only too happy to tell you about. Car insurance, home insurance, and business insurance. If you have anything that you want to ask him after we've finished here, he's sitting very patiently with a pile of business cards to hand out and any information you may want. So aside from the personal insurance, we also have secured a deal with TELUS Mobility, some fantastic cell phone rates. All the information will be posted on the website. This, of course, is in addition to the existing offers that we have from Carswell and E&O Insurance. And we also have about to finalize a deal with TD Bank. Not that you have to be a customer of TD, but they're offering a fantastic deal on point of sale terminals for accepting credit card and debit card payments. But again, I stress you do not have to have your own banking through TD. You can have your own bank, but TD offering this service, again, the details will be available online. And don't forget about our healthcare benefits as well. That's also available online. So two new, if those of you haven't seen Facebook this week, two new members were appointed to the board to fill vacancies. Their positions will be there until the AGM in November, when an election will be held to secure those places for the coming year. The two new directors are Dawn Burke from North Bay. She's currently the chair of the Regional Membership Committee, and Chris Saruriak from London, who is a past president of the PSO. And they're looking forward to working with the board on your behalf. And Dawn is, in fact, in Sudbury this weekend coordinating the free CPD session that they organised for all paralegals from that part of the province. For those of you who don't always want to come here every month, we've upgraded the webinar service to allow an unlimited number of people to sign in. And I apologize to everybody that couldn't get on in the previous months. The internet connection and the bandwidth isn't that good in this area, and that was causing all sorts of problems. We're hoping that's been corrected. Plus, of course, the system previously couldn't take all the people that wanted to sign on. I don't know at this point whether we will continue here in September. That's something for the education. Probably not. The exact location will obviously be notified to everybody before the next session, which will be the end, during August sometime. So we'll be meeting, don't know where, don't know when, as the song goes. Same time, last Saturday of the month. So the first one will be in September. What else we got here? Oh, yes. Oh, yes, forgot one. Yes, Good Life membership. We have secured a family membership of something like 4 corporate rate for OPA members and their family members. Any Good Life, which will give you, whatever you go to your local Good Life, you just say that you're a member of OPA. Will they need the membership number?
We're gonna post everything on the website.
Everything will be on the website. It's a fantastic deal you cannot get as a walk-in client. So if you're in court, wherever you find your local Good Life, you want to work out during lunchtime or whatever, the country. So I'm only too happy to let you take advantage of that. Also, Council PA have put together a riding toolkit. There's a political riding, not a horse riding, and an advocacy guide, which will be posted online as well if it hasn't been already. Also, they want to know whether the idea, of course, is to contact your MPPs during the summer months. If you go onto your local MP website, they will tell you what events they are having, barbecues, not necessarily fundraisers, but just meet and greets. And that's the time to collar them in a corner, get them behind a bush somewhere in their backyard, and talk to them about AMPs or anything else you want to talk about. But, so that's where the time is ripe to bend their ear on this issue. The Council PA have invited us to participate in a webinar, about an hour and a half. It'll be after hours, after the writing toolkit is a Word document which has sample letters which you can cut and paste, including the logo, our logo to put on the letters that you're going to be sending to them. And it gives the acceptable or accepted method of contacting your riding association and speaking with your MPP, and asking for a meeting at their constituency office, let alone going to their barbecues. The advocacy guide is a PDF document. Again, it's easily downloadable. Tells you everything you need to know, how to do it, and I think as well, more importantly, what not to do. Now, what council have asked is, in order for them to assist us, is if you're willing to put your name and your postal code, they will ascertain who your MPP is, and then they will coordinate with us as well. So if you are interested, I'm going to pass this around. If you want to put your name and put just name and postal code, and we'll pass it on to council. That is about everything in this. Brian, you have Lenny, anything you want to know? All right. So. What do you mean membership card? You mean like we did with the LPA? You mean business cards?
Yeah. No,
Business.
like membership cards that were a member of OPA.
I don't know. Why do you need them?
Because you just talk about good life, stuff like that. This way you don't have to prove everything. You've got your
Right.
membership card with your name on it.
I don't know how is going to work. Maybe Brian, you can help with that.
The Good Life deal that we have that I was able to negotiate on behalf of LPA is that up to 4 family members can join at the corporate rate. The corporate rate is $37 and change plus taxes, like $42 a month.
It's not that bad. What I'm saying, I have all kinds of membership cards from the Canadian Institute of Management and all the rest of it. I'm a member of that P2 anyway, but we don't get any from OPA.
Well, again, that's something that we can definitely bring to the board's attention in during the summer months.
Until these plans were put in place, you didn't need one, really.
Yeah, but we're now established.
Now, then we'll look into the possibility of getting that. Yeah, but it costs money. Some people don't want us to spend anything. Well, be surprised how many people don't want us to spend anything.
Well, right now we have the problem is the logistics of everything, right? We have 850 good standing members right now in the association, and we're growing quickly, and we're probably going to hit 1,000 by the fall. Well, it's a matter of logistics, how to get them to it. It's not a matter of just printing it. You have to get them to the people, right? And that's the cost involved. That's the problem, right?
We can do a mailing, certainly. Yeah.
Oh,
50 times 77. Yeah.
When we can send out a delivery here for a Tuesday, like colors.
Well, we can't. Well, we could send it out by email, maybe. You can print it off and cut it out and laminate it.
Yeah, that's a possibility. Absolutely.
Yeah. Yeah.
Again, membership card for every year.
We'll look into it. Yeah. Right. So that's everything. If the list is passed around to put your, or maybe have it at the back there. Right. It's at the back desk. The list. Name and postal code. Right. If you want to put it down, just see at the back table there, and then we'll pass it on. Thank you, everybody.
Okay, I need to grab the laptop.